So welcome to day 7 recap, and yesterday we did mainly provisions of section 188, that is related party transactions, and 189, the registers in which of contracts in which directors are interested. So in case of related party transactions, first we saw the related party concept. And so what is related party? Related party has been defined under section 2 clause 76, and related party with respect to company, who are related parties. So we have seen 8 categories. So first is under the natural person, human beings category, we have directors or the relative along with their relatives, and the second category is KMP and the relatives. The third one is firm, in which directors, managers and the relatives are partners. The fourth category, private company, in which directors, managers or the relatives is a director or a member. Then we saw in the fifth category, in case of public company, where the director or manager is a director and holds, along with his relative, more than 2% of the share capital. So in that case also, that's the fifth category we have. The sixth category, who's a related party, is the body corporate. So in case of body corporate, whose board of directors, managing director or manager is accustomed to act as per the advice, directions and instructions, that is ADI, of the directors or manager of a company. So accordingly, the body corporate and the company are related, because this body corporate is manager, managing director and all that, they are working as per ADI of this company. And any person as on whose ADI, that is advice, directions and instructions, a director or manager of a company is acting. So again, it's a related party. And the eighth category we saw, that is a holding company, subsidiary or associate company, or associate of such company, or subsidiary of a holding company to which it is also a subsidiary, or an investing company, or the venture of the company. So these are also in relation to the body corporate. These are also related parties, and all persons prescribed is category 9. So that's all we have discussed about related parties. Then we have also seen that the LODR regulations of 2018 have widened the definition of related parties, and they modified to include a person or entity belonging to the promoter group of the listed entity and holding 20% or more of the shareholding in the listed entity. So even they will be coming under the related party definition. And then we started with the related party transaction, that is section 188. So one man having relations with 2 fat ladies, and that's 188 related party transactions. So we saw related party. Now we will see the transactions, and any transactions with the related party along with the company, of course, then it becomes a related party transaction. So which transactions we are talking of? We are talking of 7 types of transactions. Of that we saw that the first one was sale, purchase or supply of goods and materials. Then selling or otherwise disposing of or buying the property. The third one, leasing of property. The fourth one, availing or rendering of services. And then appointing an agent to do all the above 4 activities. That is appointment of agent for purchase or sale of goods, materials, services or property. So that's, we have 5. Then other 2 we have. The 6th one is related parties appointment to an office or place of profit in the company. So in the company, its subsidiary or an associate company is RPT is going to be attracted, and underwriting the subscription of any securities or derivatives of the company will be also attracting section 188. So if an underwriter is a related party falling under those 9 categories, then becomes a related party transaction. So that we saw that these 7 types of transactions related to goods and materials, property comes twice, sell, lease, sell or dispose of or buying or leasing it off, and then services, then appointing an agent, and then appointing a person in office or place of profit, and the underwriters. So if any of these parties are related parties, then definitely section 188 will be attracted. And we also saw that the board approval is required. Prior approval of board is required, and in case if a company has a paid up share capital of rupees 10 crores or more, then No contract or arrangement be entered without prior approval of shareholders. So shareholders prior approval is required, prior permission is required of shareholders in case the paid up share capital of the company is 10 crores and more. Then this provision we also have to read with the proviso, with the rules, Rule 15. And Rule 15 is discussing about contracts or arrangements with related party. So that is, the agenda of the board meeting should disclose all the items, that is the name of the related party and the nature of relation, nature and particulars and duration of the contract, material terms and conditions of the contract, advance paid or received for the contract if any advance money has been received by the company, or manner of determining the pricing and other commercial terms, whether all factors relevant have been considered, and any other relevant and important information needs to be provided in the board agenda, because board will be accordingly discussing. So all intimation should be sent to the board members before the meeting starts. Then there are certain figures have been provided, that there are certain limits. If you are crossing those limits, then all these transactions comes into picture, means all these permissions and all those things comes into picture. So where any director is interested in any contract, such director shall not be present at the meeting during discussion, one thing, and only after taking prior approval of share by resolution, a company can enter into transaction where it is entered into for contracts or arrangements under section 188 A to E. That is what we saw first five as mentioned below, and then we have other two also. So in case of sale, purchase, supply of goods directly or through agent, then it should be not more than amounting to 10% of turnover or rupees 100 crore, whichever is lower. Then only permissions come into picture. Then selling or disposing of property amounting to 10% of net worth or rupees 100 crore, whichever is lower. Leasing of property amounting to 10% of net worth or rupees 100 crore, or 10% of net worth, 10% of turnover or rupees 100 crore, whichever is lower. So in leasing we have both the 10 net worth and turnover. Then availing or rendering services directly or indirectly through agent amounting to 10% of turnover or rupees 50 crores, whichever is lower. Then we have appointment to office or place of profits. So monthly remuneration is exceeding rupees 2,50,000, then 188 is applied. And remuneration for underwriting, if it's exceeding 1% of the net worth of the company, then permission is required. So primarily we will notice that related party transactions are required to be approved by board, 10 crores or more paid up capital, shareholders prior approval. However, all these comes into picture when it is exceeding particular limits as prescribed in Rule 15. That is 10% of net worth, turnover, or 100 crores or 50 crores, or 1% or 2,50,000 remuneration, depending on case to case basis. So that's about related party transactions. And the turnover or net worth is computed on the basis of audited financial statements of the preceding financial year. And in case of wholly owned subsidiaries, the resolution passed by the holding company shall be sufficient for the purpose of entering into transaction. An explanatory statement, when we take shareholders approval, we definitely have to send explanatory statement which will have all these details, that is details about the name of related party, name of the director or KMP or interested, nature of the relationship, nature, material terms and monetary value, and any other relevant information needs to be prescribed. And so that's all about related party transactions. Along with that, we have to take approval of RPTs as mentioned in LODR amendment regulations, that the amendments in the clauses pertaining to the approval of related party transactions allows related parties to cast a negative vote, as the Kotak committee believes that such a vote cannot be considered to be in conflicting in nature. Conflict of interest is not there when there is a negative vote. And such an amendment has been made in order to plug the gap in the legal framework wherein Companies Act allows related parties to vote on but not in favor of a transaction in which they are interested. On the other hand, currently SEBI LODR required all related parties to abstain from voting. Now they have added that negative voting is allowed. So this brings consistency between both laws, that is Companies Act and SEBI LODR regulations. And the amendment comes into effect from half year ending of 31st March 2019. And one more thing regarding royalty and brand payments which are being paid by one company to another company. Normally the subsidiary company pays to the holding company, whatever the case is. So whenever many companies, they make payments towards royalty and brand usage. So shareholders will be able to comprehend the terms. So now we need to recognize the value recognizing value in brand strength and product technology. This will help the shareholders to comprehend the terms and conditions of such payouts, and the amendment intends that all companies make better disclosures on the value of a company derives from a brand or a technology. So when I'm availing any brand, I'm using any brand or a technology of any other company, and I'm paying them any royalty, what is the value derived from that brand or technology is required to be disclosed in the annual reports so that the shareholders are well aware about it. And then we saw section 189. Section 189 discusses about register of contracts in which directors are interested, and that primarily the registers will be produced and will be placed at the AGM also, and keep one or more registers giving particulars of all contracts or arrangements to which section 184 or 188 applies. So it will be one common register. They should be placed before next board meeting and signed by all directors present at the meeting. That is also important. Plus, every director or KMP should within 30 days of his appointment or relinquishment disclose particulars as per section 184 relating to his concern or interest required to be included in the register. And the register shall be produced at commencement of every AGM and remain open. Further, the contents of the registers, that they will be primarily in MBP 4. Enter following particulars, that is company or companies or body corporates, firms and other associations, their names will be there, and contracts or arrangements in which any entity under section 184 subsection 2 in which director is directly or indirectly concerned or interested, contracts or arrangements with a related party to which section 188 applies. So all these details will be provided in MBP 4. Then we saw section 190. 190 we just gazed through, that is contracts of employment with MD or whole-time directors, and they are required to be kept at the registered office, and contracts of services with MD or whole-time directors, or they are required to be maintained in written form itself. There needs to be in written memorandum. And payment to directors for loss of office in connection with transfer of undertaking, property or shares is discussed in section 191. However, no compensation will be paid if they are transferred from one business, from one undertaking to another undertaking. And section 192 discusses about restrictions on non-cash transactions involving directors. So there should be no transactions in kind exactly. Everything should be in cash terms. And contracts by OPC. So whenever contract by one person, he enters into contract with himself. In that case, he ensures that the terms of contracts are contained in a memorandum and are recorded in the minutes of the board meeting held next. And this subsection shall not apply to contracts entered in ordinary course of business. Further, company informs the registrar within 15 days of the board approval. So that's all about Chapter 12. We have discussed all provisions of Chapter 12, and that's the complete recap.